Hello there. Welcome to video 170 from Sumit Academy. I do hope that you have subscribed to my channel. Do subscribe now so that you do not miss out on my previous or future videos. And do remember to like and share this video too. Do remember that the videos on my YouTube channel are for you to use for your examination purposes. They are free to use and will always remain free for you all. Do use the information in these videos to the best of your ability to succeed in your endeavor to join the civil services. To make your task a little easier, here is a complete list of all the 170 videos available on my YouTube channel. The list is divided into the playlists under which they are available. Do have a look. In this video, we shall study the Companies Act of 2013. I do hope that you have seen my earlier 3 videos on corporate governance, since this video will also be referring to the concept of corporate governance and as to how this act is an important step towards corporate governance. The Companies Act of 2013 is an extremely detailed and elaborate legislation that is aimed at regulating the incorporation of companies. It sets out further details on the responsibilities of a company, its directors, and how the dissolution of a company can take place. This act partially replaced the older company law legislation, that is, the Companies Act of 1956. The new law is aimed at easing the process of doing business in India and improving corporate governance by making companies more accountable. The 2013 Act also introduced new concepts such as one-person company, small company, dormant company, and corporate social responsibility, that is CSR. The Act introduces significant changes in the provisions related to governance, e-management, compliance and enforcement, disclosure norms, auditors, mergers and acquisitions, class action suits, and registered valuers. The Companies Act 2013 has taken a foot forward, or rather a step forward, from SEBI's Clause 49 of listing agreement by introducing provisions which promotes corporate governorship code in such a manner that it will no longer be restricted to only listed public companies, but also to unlisted public companies. The Act provides an elaboration on the various steps to be taken to form and dissolve a company and creates provisions for various other mechanisms such as corporate social responsibility, role of company secretaries, the role of the National Company Law Tribunal, and the National Financial Reporting Authority. Let us study some of the important provisions of this Act. The first of this relates to the Board of Directors. Now, this is a decision-making body of any company. It is the duty of the board to comply with all legal rules and regulations. As for the composition of the board, Section 149 of the Act provides for appointment of a minimum of 3 directors in a public company and 2 directors in a private company. A board can have a maximum of 15 directors but can appoint more directors subject to special approval. It is also mandatory to appoint a woman director in a public unlisted company having paid up share capital of 100 crore rupees or more, or having a turnover of 300 crore or more. The next provision is the setting up of a stakeholder relationship committee. As per section 178(6) of the Act, if a company has more than 1,000 shareholders, debenture holders, deposit holders, or any other security holders in a financial year, then it is mandatory to constitute a stakeholder relationship committee. The main aim of the committee is to resolve conflicts between shareholders and the board of directors and address their grievances. The chairperson of the board shall be a non-executive director. Next, the audit committee will look after the financial reports and disclosures of a company. It is one of the most important components of a corporate governance structure. It will consist of a minimum of 3 directors, and independent directors will form the majority. Incorporation of a company. Now, according to this Act, a company can be formed for any lawful purpose. The minimum requirement for a public company is that it must have 7 or more members and 2 persons where the company formed is a private one. Even a 1-person company can be formed which has only 1 member and is a private company. For the company to be legally recognized, it must be in compliance with this Act. Next is Prospectus and Allotment of Securities. Any public company can issue shares and securities after making a public offer through a prospectus. A private company can do the same by way of a rights issue, that is, distributing the rights in the company or through private placement. The Securities and Exchange Board of India, SEBI, regulates the issue and transfer of securities. Management and administration is the next point. This is perhaps the most important provision of the Act from a company's perspective. It lists out the roles and responsibilities of a company. Every company must also prepare and maintain an annual return report, which records its principal business activities, shareholders, and shareholding patterns, its debt, its members, its promoters, its directors, and key managerial persons. The company must also hold an annual general meeting every year. An important provision of the Act is the corporate social responsibility. The Act prescribes that every company having a net worth of 500 crores or more, or a turnover of 1000 crores or more, or a net profit of 5 crores or more during any financial year should constitute a corporate social responsibility committee, a CSR committee, with three or more directors of the company, with at least one independent director amongst them. Now, this CSR committee must formulate and recommend to the board a CSR policy. CSR policy is a strategy that encourages a company to make contributions that have a positive impact on the environment and consumers. Our next point is prevention of oppression and mismanagement. These provisions are there to ensure that the affairs of the company are not conducted in a prejudicial manner. Any member of a company can seek relief from the Company Law Tribunal if they feel that the affairs of the company have been or are being conducted in a manner that is prejudicial to public interest or even the company's interests. The next clause of the Act is revival of sick companies. If on demand by the secured creditors of a company representing 50% or more of its outstanding debt, a company is unable to pay the debt within 30 days of the demand to the satisfaction of its creditors, then such a company will be determined to be a sick company. Once a company is determined to be sick, any secured creditor of that company can make an application to the Company Law Tribunal to seek the measures to be adopted with respect to the revival and rehabilitation of such a company. A company administrator will be appointed to take over the management of such a company. This part also has provisions for the creation of a rehabilitation and insolvency fund, which will be credited with funds from any grant made by the central government. Any amount deposited by companies as a contribution to such a fund, the amount secured from any other source for the purpose of the fund, and income from investment of the amount from the fund. An important provision in the Act is about the winding up of a company, a closing down of a company. Now, there are two modes of winding up, that is, closing down a company: by the Company Law Tribunal or through a voluntary measure. A company can be wound up by the tribunal if the company is unable to pay its debt or if it acts against the interests of our nation. A company can be wound up voluntarily if the general body passes a resolution for winding up. On either occasion, there must be responsible steps towards ensuring that creditors are paid back where possible and consumer interests are taken care of. National Company Law Tribunal is another clause of this Act. This Act provides for the constitution of this tribunal. Now, the president of this tribunal should be a person who is or has been a judge of the High Court for 5 years. The company law appellate tribunal has the same constitution as the company law tribunal and can have 11 members. After the constitution of this tribunal, the civil courts of the country no longer have jurisdiction over the matters filed in this tribunal. Now, you may well ask me, why do companies need good corporate governance? Well, every company should have an ethical corporate governance code as it reduces the risk of fraudulent activities by the top management. Good corporate governance structure enables accountability in the organization and makes sure that directors, management, and employees do not indulge in fraudulent and unlawful activities. The Companies Act of 2013 gives a lot of importance to ethical corporate structure by penalizing the officer in default if they do not comply with the same. Independent directors can play a vital role in having effective corporate governance by helping the company formulate policies and representing the shareholders' grievances. The Companies Act of 2013 empowers independent directors with proper checks and balances so that such extensive powers are not exercised in an unauthorized manner but in a rational and accountable way. The changes are a step forward in the right direction to smoothly run the management and affairs of the companies in the interests of stakeholders. Now, these are all welcome changes in the globalized corporate world of today and surely will strengthen the core corporate machinery by instilling strong corporate governance norms in a company. This will lead to economic efficiency and higher ethical standards. Well, that's all from me in this video. This video is based on the information freely available on the internet. No originality is claimed for the same. The intention of this video is only to prepare candidates for answering examination questions on the subject and not for any financial gains. Do like and share this video and do subscribe to my channel now so that you do not miss out on my previous or future videos. Till later then, cheerio.